Wills and trusts are important to have for what happens when you pass away. But during your lifetime, it's critical to have documents in place regarding healthcare decisions and financial decisions if you're not able to make those decisions due to incapacity or otherwise. The consequences of not having these documents in place mean that your family or friends are spending more time and more money dealing with difficult situations, which are difficult to start with. So proper planning can alleviate much of the burden with regard to the mechanics of dealing with those situations if an emergency arises. And that's really what we want, right? We want to make sure that our family is protected and that we're protected as much as we can.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth. Pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it accessible and understandable to those who need it. So, if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic. Today's topic is on life support, estate planning considerations for uncertain medical situations. Because you have to consider what might happen, an unforeseen medical situation affects you. So on today's show, we're talking about on life support, estate planning considerations for uncertain medical conditions. So let's get to it. Freddie Mercury said, "I don't want to die," in their famous Bohemian Rhapsody song, which is an excellent song. If you haven't listened to it in a while, pull it out. It's really good. Nobody wants to die, right? But even fewer people want to be sick or incapacitated during any time of their life. Unfortunately, planning for these situations often gets short shrift and less attention than getting your will done or getting your trust done. Now, don't get me wrong, wills and trusts are important to have for what happens when you pass away. But during your lifetime, it's critical to have documents in place regarding healthcare decisions and financial decisions if you're not able to make those decisions due to incapacity or otherwise. The consequences of not having these documents in place mean that your family or friends are spending more time and more money dealing with difficult situations, which are difficult to start with. So proper planning can alleviate much of the burden with regard to the mechanics of dealing with those situations if an emergency arises. And that's really what we want, right? We want to make sure that our family is protected and that we're protected as much as we can. And that's why we do estate planning, right? That's why we're here. That's what we're doing, right? And so today we're talking about some things to consider and ways to address these uncertain medical conditions that could come up in emergency situations in particular. And so the first thing to consider, and we've talked about this in other episodes a lot, right? We talk about powers of attorney and healthcare directives. We did an episode real early on, durable powers of attorney specifically. I think it's episode 7 if you want to go all the way back there. But for today, we're talking about more of a healthcare and more generally in emergency situations, what do you want to have? And so the first thing to consider is having an advance directive or advanced directives in general, right? And advanced directives are things like healthcare directives and durable powers of attorney for healthcare, living wills, which you hear. And so they're legal documents that outline someone's preferences with regard to medical care if they become incapacitated and unable to communicate their wishes. And they can specify whether someone wants to be kept on life support, relieving sustaining treatment, be allowed to pass away naturally, under certain circumstances. And they give someone that you trust control of medical situations even when you can't speak for yourself. So advance directives, number one, gotta have them. Okay. Number two thing to consider or document that's important is a living will. And in Washington, we call living wills healthcare directives. And the living will or healthcare directive specifically addresses the types of medical treatment one wants to have or doesn't want to have. Okay. It's essential with regard to end-of-life treatment and life support situations, whether you want to have artificial nutrition or artificial hydration after life support has been removed. And it allows individuals to express their wishes in advance of these situations becoming situations at all, sparing your loved ones from having to deal with this and make these decisions for you. Because it's hard enough when a friend or family member is having a critical moment. And so having these decisions pre-made, well, you know what mom wants or what dad wants or Bobby wants, makes it so much easier. Number three, durable power of attorney for healthcare. Appointing a healthcare agent under a durable power of attorney for healthcare designates this trusted individual, which could be a friend or family member, brother, whatever, mom, dad, spouse, to make healthcare decisions if you're incapacitated, okay? Sometimes they are called a healthcare proxy. You'll hear that word too. They have the authority to make critical medical decisions that align with your wishes as outlined in your directives, okay? And it's particularly important for these unpredictable, uncertain conditions that happen in emergencies, and quick decisions need to be made. So one thing about healthcare durable powers of attorney, okay? Typically with a durable power of attorney, you can make it effective immediately, or in many cases, people make them effective only upon incapacity. And so I've been practicing for 21, almost 22 years. And when I was a brand new lawyer, I was really worried about somebody stealing every little old lady I met's money that was named as a power of attorney for them. And what I learned over a short period of time, actually pretty early on, is when there's an emergency situation, getting that power of attorney that's effective upon incapacity to be approved and usable by a hospital or a doctor's office or emergency room in particular is pretty difficult. And it's hard to find a doctor to say, hey, yeah, they're incapacitated now, or a court to say, yep, they're incapacitated, especially when it's night or it's on the weekend. And so I typically recommend that you have your durable power of attorney documents effective immediately. The reason why is that if you're in a situation where it's an emergency, the person that you appoint can make those decisions right away without having to go to court, without having to get a doctor's letter or something like that, okay? And so those decisions, which are usually life or death decisions and have to be made quickly, can be made quickly. The other thing to consider having with regard to medical decisions is a HIPAA authorization form. HIPAA stands for the Health Insurance Portability and Accountability Act. It protects medical information. That's the point of it, okay? And it often prevents family members from getting medical records that they might need in an emergency situation without permission, okay? And so by having a HIPAA authorization with regard, or in your estate plan, or as part of your durable power of attorney, avoids the ability not to get, someone's medical records so that you can clearly communicate wishes with regard to their medical treatment. And so this authorization ensures that healthcare agent and other trusted individuals have information they need to make this informed decision. So sometimes they may not know exactly what your issues are and if there are any complicating issues. So if you show up at a hospital or emergency room unconscious and your agent under the healthcare durable power of attorney can't get medical records and doesn't quite know, well, this is what they had, they might not know, because sometimes people don't tell their family or their friends everything they have wrong with them medically. And so knowing that information or having access to those medical records is key. Okay, what happens if I don't want to come back? Okay. Do not resuscitate orders or POST forms. A do not resuscitate order instructs healthcare providers not to perform CPR if an individual stops or their heart is no longer beating, okay? Or if they stop breathing. So DNR, don't bring me back if my heart's not working, I can't breathe. I'm not breathing, I guess I should say. Additionally, many states, including Washington, have a form called a POST form, which stands for Physician Orders for Life-Sustaining Treatment. A POST form is one you get from your doctor, probably, right? And it goes beyond the DNR as it details instructions as the patient's preferences for emergency medical treatment, including use of ventilators, feeding tubes, other interventions. Usually the POST form is the one that you stick on your fridge. When I go to clients' houses, little old ladies' houses oftentimes, and the doctor will tell them this too, There's the post form is right up on the fridge. And the reason it's on the fridge is because when the EMTs show up, if there's a critical event, they'll see it and they'll know, don't bring her back, or please bring me back, or try it for this long. Those post forms are pretty detailed. They're more detailed than like a healthcare directive, say, which just talks about hydration and nutrition and whether you want either of those. So those post forms are done under the direction of your physician. You'll get them from your physician. They do not charge you for them. And I think you can even get them from like state websites in Washington. So those are important to have, particularly if you're an older individual. Like, I don't have one. I tell clients that are maybe in their 80s to start thinking about it. Okay. We're not just talking about healthcare decisions. Number 6 would be talking about a financial durable power of attorney. Okay. And we're mainly talking about medical conditions, but I wanted to mention a financial durable power of attorney because sometimes you have to pay for a doctor bill or something like that, right? And so financial durable power of attorney is much like a healthcare durable power of attorney, where the financial durable power of attorney allows someone to be appointed to make financial decisions for you, which means they can pay your bills, they can write checks for you, they can transfer money if they need to, and do things like that. And also, if you go back to the episode 7, which talks about durable powers of attorney specifically, you can do estate planning documents sometimes, you can make trusts sometimes, you can change beneficiary designations sometimes, you can help plan for long-term care under a financial durable power of attorney. And so that's sort of related to healthcare, right? You can relate that to long-term care planning. If you need to get on a program like Medicaid or something, a durable power of attorney finance that has the adequate and proper provisions in it would be a benefit there. Number 7, this is something to consider with regard to incapacity planning too. And I know I talked about, well, we're not going to talk about trusts today because we're talking about powers of attorney, but a revocable trust can be a significant tool in managing someone's affairs. So a revocable trust can help with these uncertain medical conditions by placing these assets into the trust. The individual who does so can name a successor trustee who can come in and help make decisions later, right? And help deal with these assets later if they become incapacitated. And the trust avoids the need for probate and avoids court intervention and avoids having to report to the court during ongoing maintenance and things for the trust. And so during your hospital stay, potentially, your medical bills are paid, your investments are managed, and your financial needs are met, okay? And other than that, when you pass away, it doesn't go through probate. It distributes things according to your wishes directly without any major hassle, okay? And that leads us to the worst case scenario. Guardianship is something to be avoided unless it's a last resort, okay? And guardianship or conservatorship, guardianship in Washington relates to personal decisions. Conservatorship relates to financial decisions. So if an individual who is incapacitated does not have advance directives or durable powers of attorney in place, their friends and family might have to seek this guardianship or conservatorship, oftentimes both, through the courts. And these procedures require appointing individuals to make decisions, both medical and financial, over an individual who's incapacitated. And while they can provide protection and they solve the problem, they're often expensive, they're time consuming, they require a lot of reporting to the court, a lot of approvals by the court, and intervention by the court, like transfer assets or sell a house or something like that, all requires court intervention and court approval. And they can lead to serious family conflict as to what happens because mom or dad never told the kids what they wanted to have happen. Potentially, if they don't have a power of attorney or a healthcare directive, they never told the kids. So you have a mess, potentially. So avoiding guardianship or conservatorship through a durable power of attorney for finance and medical decisions, and through a revocable trust like we just talked about, that can avoid a conservatorship, is a huge benefit. So think about a trust if you haven't done it. Try to avoid guardianship if you can. Now, something to consider, and we just alluded to this a minute ago, when you're making these healthcare decisions, when you're getting older, like I haven't talked to my family, I'm 49 years old. I don't know, maybe I should talk to my wife or my kids about how to do this if something happens to me. I have the documents in place, okay? I've got the documents, but I haven't had this discussion. So communicating your wishes with your family and your caregivers is important to avoid disputes. Even the most thorough estate plan can lead to disputes if you don't talk to your family about it, okay? That's not to say you have to get their approval for what you've done. I do not recommend talking to your family to get their approval with regard to how you decide to distribute your estate, okay? It's your decision. You don't have to have their approval. But you should let them know once you've done it that this is what I did and what I say goes. Because you don't want to have a conflict there, right? You want to have these open and honest discussions and let them know where you stand and what you expect to have happen pursuant to the documents that you've put in place, okay? And so this ensures that everybody understands the individual's preferences and reduces the risks for disputes. It takes the second guessing out of it, makes medical decisions much easier. And it goes back to like healthcare directive. Like we've talked about Terry Schiavo, I think, on this podcast before. That was a case probably 20 years ago in Florida where a wife was on long-term life support and her husband said, I really would like her to come off. She's not going to survive. She's not surviving. And her family, her parents wanted her to stay on life support. And so actually I did talk about this in an episode more extensively, but having that document in place and having these discussions and knowing exactly what someone wants are really important to have this family harmony remain. So, finally, I'll talk about this, okay? Actually, two more things. Death with dignity. Washington is a state where you can die with dignity, which means if you're terminally ill and mentally competent, if you have a prognosis of 6 months or less to live, you can request to self-administer life-ending medication. And I've had a bunch of clients ask me about this a lot, and I've had one client who actually did it. But there's a lot of hoops to jump through, and it's something you have to plan ahead. And you have to be competent. And you have to, in the moment, be 6 months out from death. So you've got to plan for it. It's not for everyone. And if you do it, you want to have these discussions with your family. And there's lots of documentation to put in place with the state and with your medical provider. And your estate planning should incorporate these desires, okay? Related to death with dignity, ensuring that the appropriate legal and medical steps are taken with regard to your interests, okay? And don't worry, like your kid can't put you down. It's not euthanasia, right? Like you can't be euthanized by your child if you're old and have dementia. That's not going to happen. Hopefully that'll stay illegal. We'll see. But this is a very limited scope where if you're under 6 months to live, and you have full competency and can make that decision, you can sign up for this program. Finally, when we're talking about capacity, we want to make sure we do these documents while our brains still work, while we have legal capacity, mental capacity to do our documents, okay? And so when we're creating our estate planning documents, we want to make sure that you know what you're doing, that you know who your family is, that you know what your assets are, that you know what your structure is, right? That you know what your wishes are with regard to where your stuff goes. Because if you don't know those things, you would not have legal capacity to sign your documents, which would put us back into that let's avoid this guardianship mode, right? We don't want to have to do a guardianship. And so do these documents when you are healthy. Do not wait. That's the thing. So a story regarding that, I met with a client just this week, a son and daughter and their mother in her 80s. And they came in because they wanted to do a power of attorney and a will for mom. And we were going to do it. And then mom shows up. And mom didn't want to be there. She was in a bad mood. But I've been doing this 20-something years, 22 almost years. And I know when someone has capacity or not, or when their dementia is to the point where they do not have capacity. Mom didn't know who her daughter was. She didn't know her name. She didn't know her son's name. She didn't know what town she lived in. She didn't know who she lived with. She didn't know what her assets were. So it was too late for them. And so they're going to have to do a guardianship. That's their mode, right? That's their path at this point. It solves the problem, and it will help them deal with her medical issues and financial issues. But it's a lot more complicated, and it takes a lot longer, and it costs more money. So plan ahead and plan ahead. Okay, so that brings us to our story time. And this is a good story with regard to the topic today. Okay, because this is kind of a dark topic. Well, what do we do if we're having an unforeseen medical consequence or medical situation? That's a rough topic, right? Like, hopefully people are listening to this, yeah? Are you listening? So the story is this. This is a success story with regard to a durable power of attorney, okay? A friend of mine, her family was on vacation. Her older parents and brother were on vacation. She was on her way to meet them, and her father had a major cardiac event, okay? And they're out in the boonies, basically. There's no major hospitals there. There's not a lot there. And Dad has a major cardiac event, and the EMTs came, kept him alive on CPR, and he couldn't make a decision. He's unconscious, right? Thankfully, he was brought to the hospital. He was stabilized. But because she had the durable power of attorney for her dad, she was able to coordinate his care. She got him transferred from the local hospital to a more regional hospital and then to a even better hospital. She dealt with all the transport decisions, dealing with all the doctors. She mentioned that if, once she got there, and talked to the nurses on the board in the room, it says, well, power of attorney, call so-and-so. And whenever she called in to get an update, they gave her updates. Whenever she gave them direction, they listened and they followed that to the T. And if she didn't have, that wouldn't have been possible. And her mom wasn't able to help. Her mom was very worried, and that's not her thing. And so this power of attorney allowed her to deal with the doctors and surgeries and transportation between multiple hospitals. So her dad was taken care of. And this is a scary situation. And so not having like a document that sort of makes the mechanics of dealing with it easy makes it all the worse, right? Because you're already worried, you're already sad, you're already freaked out because your mom or dad is, in a significant life event. And so having that smooth path forward really simplified the process and made it much more manageable. And so I'm really happy to hear stories like that, because that's what I preach, right? Do your stuff. Do your planning. The power of attorney is probably the most important document you can do during your lifetime, for your lifetime, okay? Healthcare directives second, maybe. Will or trust are good to have when you pass away, for sure. But during your lifetime, if you're not going to do any estate planning, at least do a durable power of attorney. Do a healthcare directive. Just make your kid's life so much easier. So, well, I think that's it for today's episode. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.